All right, everyone, welcome back. We good? We can start? Okay. Welcome back, everyone. Hopefully, had a nice week so far. I have some interesting news. So, when I tell you that we are learning on the cutting edge of constitutional law, I am not joking. So, after our class last time, I was invited by the U.S. House of Representatives, the Judiciary Committee, to go to Washington, D.C. to testify on the constitutionality of DAPA. And this is a topic which we discussed in class, which I think I told you there's no one else in the country studying this, and I meant it. So yesterday I flew to Washington for basically less than 24 hours to go give my testimony. And I want to show you my opening statement. And you've read my article, so you know what I think. But this provides a fairly short summary of the nature of the issue. Also, I'll show you another clip afterwards. So if you can see for once, me getting grilled instead of me grilling you. Because the way this works is we get a 5-minute opening statement. And then I spent the 3 hours members of Congress ask me questions. It's grueling. So here's my opening statement. Might take a second to load.
11 seconds over.
Yeah, actually I was on time. They have a timer on your desk. I clocked in at 4 minutes, 44 seconds. So actually I timed it just perfectly. That was about my range. I was a little bit faster, but anyway, so it takes a second to load.
So how many people are in front of you?
It's the weirdest thing. There's like 25 members of Congress sitting in this huge bench in front of you.
Okay.
With microphones?
With microphones and everything. And the weirdest part is there are these guys sitting on the floor with cameras taking pictures of you. They're on their knees like a catcher in baseball would be. So it's fascinating to watch. Oh, come on, video, work. It gave me problems in my morning class. So I'll summarize it before I play it.
25 members, that's an awesome committee.
It's this is the committee of the whole. So they have subcommittees and committees. This is the committee of the whole. It's like 15 Republicans and 10 Democrats, give or take. I might be off by 1 or 2. Let's try this again. Let's try it like this. I couldn't get it to work before. Try this. Oops. Okay. This is why I never show videos in class. They never work right. No matter what.
For this committee about this important issue. Thank you, General Laxalt. Professor Blackmun, welcome. I understand your parents are with us today.
My dad's in the same color tie, so you know who he is.
Excellent.
Thank you. Chairman Goodlatte, Ranking Member Conyers, and members of the Judiciary Committee. My name is Josh Blackmun, and I'm a constitutional law professor at the South Texas College of Law in Houston, Texas.
Woo.
I am honored to have the opportunity to testify about why DAPA violates the Constitution and poses a severe threat to the separation of powers. In my brief time, I have 3 points. First, DAPA is an unprecedented exercise of presidential lawmaking power and is not consonant with previous exercises of deferred action. Second, DAPA violates the president's duty to take care that the laws are faithfully executed, as the executive must enforce the laws in good faith. Third, I will sound an alarm. Non-enforcement poses an encroaching threat to the separation of powers and the rule of law that Congress, not just the courts, must take steps to halt. So first, Congress has not acquiesced or given the president the authority to implement DAPA. The Justice Department's Office of Legal Counsel claimed that 4 previous instances of deferred action justify DAPA and its antecedent DACA through express or implicit congressional approval. These claims are demonstrably false. So first, in 1997, deferred action was granted for battered aliens under the Violence Against Women Act, VAWA, where a petition had already been approved, but a visa was not immediately available. Here, the deferred action served as a temporary bridge for those who would soon receive permanent status according to the laws of Congress. Second, in 2001, deferred action was granted for aliens who were readily deemed to be bona fide under the Victims of Trafficking and Violence Protection Act. Here, too, the deferred action served as a bridge. Lawful status was immediately available on the other side of the deferral. Third, in 2005, deferred action was granted for foreign students who unfortunately lost their visas when Gulf Coast schools were closed following Hurricane Katrina. The deferred action bridged the gap and gave the students 4 months to enroll at another college or university in order to regain the status they previously held. Fourth, in 2009, deferred action was granted for aliens that were widowed by the untimely death of their citizen spouse before the minimum 2-year period. Deferred action was granted where visa petitions have been filed but not completely adjudicated by the government because of administrative delays. Again, a visa awaited shortly after deferral. Historically, deferred action acts as a temporary bridge from one status to another, where benefits were construed as immediately arising post-deferred action. In contrast with DAPA, deferred action serves not as a bridge, but as a tunnel to dig under and through the INA. There's a pot of gold awaiting the other side of this deferred action rainbow. My second point is that DAPA violates the president's duty to take care that the laws be faithfully executed. Article 2 imposes a duty on the president unlike any other in the Constitution. He must take care that the laws be faithfully executed. DAPA violates his duty for three reasons. First, with DACA, the blueprint for DAPA, the administration limited officers to turn discretion to rubber stamp. This did not reallocate resources to further congressional policy, but rather was an effort to bypass it, and a transparent one at that. Second, because DAPA is not consistent with congressional policy, according to Justice Jackson's decision in the Steele seizure case, presidential power is at its lowest ebb. Third, like the mythical phoenix, DACA and DAPA rose from the ashes of congressional defeat. The president instituted these policies after Congress voted down the legislation he wanted. Further, the president repeated over and over and over again that he could not act unilaterally in the precise manner he did. His actions and statements create the prima facie case of bad faith and point towards a violation of the Take Care Clause. Third and finally, while I support comprehensive immigration reform, the president's unconstitutional actions cannot be sanctioned. I hasten to add, if upheld, Democrats have much, much more to fear from this dangerous precedent. Generally, Democrats like when the government takes more action, and Republicans like when the government takes less action. Today, Democrats may approve of the president's decision to halt deportations, delay unpopular provisions of Obamacare, or not prosecute marijuana crimes. However, the situation would be very, very different if a Republican president declined to enforce provisions of the tax code, waive mandates under environmental laws, or declined to implement Obamacare altogether. In the words of James Madison in Federalist Number 51, the only way to keep the separation of powers in place is for ambition to counteract ambition. Although the courts play an essential role to serve as the bulwarks of a limited constitution, our republic cannot leave the all-important task of safeguarding freedom to the judiciary. To eliminate the dangers of non-enforcement, the Congress must counteract the president's ambition. The failure to do so here will continue the one-way ratchet towards executive supremacy and the dilution of the powers of the Congress and the sovereignty of the people. The rule of law and the Constitution itself are destined to fail if the separation of powers turn to mere parchment barriers that can be disregarded when the president deems a law broken. Thank you very much, and I welcome your questions.
All right.
Thank you.
So that was my testimony. I want to show you this one other clip because South Texas gets a very nice shout out by Representative Poe, whose district is not too far from here. This one's going to be short, just 30 seconds. I want to play.
See this all day.
Kentucky's is too much. I yield back the balance of my time.
Thank the gentleman from Tennessee. The chair will now recognize the gentleman from Texas, Judge Poe.
I'm over here on the far right. Let me ask you some questions. Thank you all for being here. Professor Blackmun, thank you also for being here. South Texas. I couldn't get into South Texas, so
You went to U of H.
I'm glad you
Visit my classroom anytime, sir.
Tell Professor Treese hello. He and I are contemporaries. Quite a tribute to him, or credit to him. The school has him.
Okay. So South Texas got a nice shout out on the floor of the United States House of Representatives Judiciary Committee, which is, oh my God, yes. They asked me a question for 3 hours. It was 3 hours long. If you go through my blog, I clipped out the top 7. There were more. I didn't get all of them. But I clipped out the top 7 questions they asked me. Some of the questions were like 30 seconds long. Some of them were like 3-minute long, so went back and forth. Questions from Democrats, from Republicans, and all sorts of things. I mean, I quoted about at least 4 Federalist Papers. I got them in. I quoted at least 3 Supreme Court decisions. I mentioned Breyer and Scalia and Noel Canning. I mean, if you watch the videos, you know I'm going to say, because you hear me every week. So I effectively treated this as a huge classroom to pontificate to the American populace at large and get into the congressional record. What? Yeah, I mentioned Steele seizures. I had actually Federalist 51, 48, and 78. The 78 was the bulwarks of liberty, 48 was parchment barriers, and 51 was ambition to counteract ambition. And actually, another one of the congressmen said, what about Madison saying the power of the purse? Like, yes, Federalists. So this was my biggest classroom ever. People on C-SPAN actually watched this. So if you go to my blog, I have 7 or 8 clips that work. And if you see here, the way it works is there are 4 witnesses. That's me. There's the Attorney General of Nevada, a professor from Florida, and another professor from St. Louis, and he was formerly the top lawyer in the U.S. Customs Service. So it's a very engaging panel. Afterwards, a number of the representatives came up. They shook our hands. They were really nice about it, very cool about it, but it was exhausting. And the number one trick is you can't go to the bathroom. There's no break. It was 3.5 hours straight without a break. So,
But they're getting up.
oh yeah, they're going up. I'm talking about us. We could not get up and leave. I mean, I guess I could have left, but that would have been bad. So there was no break though. They just kept going through. They actually rotate chairs one after the other. So when one chair has to leave, they go to another one.
Who pays for you to, like, do you have to cover your own travel expenses, or do the...
I'm going to ask the South Texas College of Law if they like to pay for it. I don't know. I pay for the ticket myself. I don't think Congress pays for this. I think it's considered so much of an honor they're not going to give you money. Actually, I don't know the answer. Actually, I was Professor Carlson's there. I might ask him later, but I haven't actually figured this out yet. They only asked me about a week ago, and I didn't have a chance to check with the school. I was like, okay, and I bought a ticket like the next day, and so I didn't totally think this through. But I will submit my reimbursements and see what happens. They were reasonable reimbursements. They weren't very expensive.
Your post was on Facebook, like the last one about South. It's on the Facebook page for South Texas.
I am aware, so hopefully people see it. But anyway, so this is good publicity, but even more so for you guys in this room, you are so much on the cutting edge because we did this like 3 weeks ago. You are so ahead of the curve. You knew about this before Judge Hainan ruled. This case is currently on appeal to the Fifth Circuit, and it will resolve very, very, very soon.
And you mentioned unprecedented.
And I said unprecedented. I got it in, which is thank you, Dat, which is a perfect segue for our topic for today, which is Obamacare. I actually also mentioned Obamacare. One of the, I forgot which it was, said, oh, it was Ted Poe. He said, you know, Professor, is it possible for the president to delay aspect of the law? I'm like, we're living in that era. We've delayed Obamacare twice. So I actually got very specific references. They actually mentioned my book in my introduction, which was very generous of them. Anyway, my parents were quelling. They were happy. And yeah, they drove down from... My mom apparently bought my dad and me the same tie, and independently wore the exact same tie. Anyway. So let's talk about Obamacare, okay? I apologize for the brief interlude, but this is very, very relevant to our discussions on the constitutionality of DAPA. But let's talk about what's probably the most significant constitutional case of the decade. I'd probably say the 21st century, if we exclude Bush v. Gore, and maybe in the last 50 years, top 5. And that is NFIB versus Sebelius. So I didn't make you buy my book, but I gave you the a chapter from it, which provides a very good overview. If you want to buy a copy, you're welcome to. Amazon has it now for $5. It's bargain basement, like Kmart prices. So, but you don't need to, okay? So the reason why the book was called Unprecedented, maybe I can give an origin of the title, which explains a lot of, oh, by the way, I'm lecturing today. I usually don't like to lecture nonstop, but the only way for me to finish this is to lecture through. So you can stop me with questions, but I won't be going around and asking people questions because this is a shtick that will take a while. Okay, so why was this book called Unprecedented, right? Why did I use this word? Our legal system is based on precedent, right? When you want to do something, the question is, well, has it been done before? How would a court case decide it? And if there's some sort of court case that's on point, that says you can't do this, and then you do X, you're acting unlawfully, right? Same thing works with congressional policy. This is the point of Justice Jackson, right? When Congress says, don't do this to the president, and the president does it, well, you're acting unlawfully. But very often, it's not necessarily clear whether a court or Congress has sanctioned some behavior, right? And a common argument people make, myself included, is that what's being done now is without precedent. It's never been done before. It's unprecedented. I've said that word so many times I can't even help. Randy Barnett, who wrote the foreword to my book, took to saying that word so often that I coined the phrase saying we need a Randy Barnett drinking game, and we take a shot whenever he says unprecedented. I called it a shot for liberty. And that stuck. And that's Randy, when I said that, Randy said this is our tagline for the case, and that's how the book got its title, Drinking Game, right? But the entire Obamacare story is really a struggle between all three branches of government. You had President Obama, who came into office and made his main priority, with a 60-vote block in the Senate, healthcare, right? He didn't go immigration, which makes a lot of people unhappy, which is why we're in this mess now. He had a filibuster-proof majority, could have done immigration, but he spent basically his entire first term on a couple other things, mostly healthcare. But it's also a story of the courts, and to what extent are the courts willing to enforce the Constitution to stop actions that may violate it. Okay? So by way of background, health insurance in this country doesn't work particularly well, and I think we can all admit that. There's a lot of aspects that are very expensive, and that there's a certain percentage of people who don't have good care and are sick and get bills that are high, and they get in trouble and they go bankrupt, and there are a lot of problems with our health insurance industry. But before the Affordable Care Act was passed, by and large, people were pretty happy with their plans. A survey done in 2008 suggested that about 80% of people were happy with their plans. So this is a usual situation where there are a lot of people who are happy, and then you have some smaller chunk who are unhappy, okay? So there have been several key efforts in American history to try to reform healthcare. Eddie may be the only one who remembers this picture. Remember this one, Eddie?
Absolutely.
Remember this one?
Absolutely.
What was this?
That was when she was introducing Hillary Care.
Oh, Hillary Care. Let's go with the Health Security Act, right? The HSA, the first HSA. So this was called the Health Security Act. So First Lady Hillary Clinton proposed this idea, which have had some sort of a quasi-single-payer health insurance system where every American would get one of those cards. If you go to the Clinton Presidential Library in Little Rock, which I went about a month or two ago, they actually have the card which she held up in the hearing. It's kind of cool. So it's like, you know, John Smith, #1, right? So they have that card there. But the problem with this, as it was in 2008, was that people were generally happy with their health insurance. All right, Eddie, you remember this one? You know this one, Jason?
Yeah.
What's this one?
It's a commercial. What's their name?
Harry and Louise.
Harry and Louise.
That's right. So Harry and Louise were this Midwestern couple sitting around the table reading, you can see the president's healthcare plans. You know, this thick book. There was no internet back then, right? So they had these thick books. And they were saying, I don't know, Ma, this healthcare looks mighty complicated, right? And the other one said, I don't know, I like my doctor. I don't want to lose my doctor. I like my health insurance. This commercial was so effective, you probably remember this, that it basically killed any momentum for healthcare reform. And the entire plan went down in flaming defeat. And in no small part, this led to the Republican taking over the House in 1994, right? So we had an attempt in the 90s to do something about health insurance, and it didn't quite work out. So throughout the rest of the 90s into the 2000s, there was really nothing done on this front until President Obama was inaugurated in 2009. Now, this was his first inaugural oath, and this was his second inaugural oath. Does anyone remember why?
Robert's Club.
No, Obama, actually. So what happened was the oath was messed up, okay? It's unclear who actually messed up. I'll give you the backstory on this one. When the first oath was given, the Chief Justice was saying the words, and the President started saying the words over him. So usually, you repeat after me. I say a few words, I stop, and then you repeat them. The President had committed the words to memory. So before the Chief had even stopped speaking, he started saying words. So you're supposed to break at the same point, and they weren't breaking at the same point. So in fairness to the Chief Justice, he had sent to the White House a paper which said, I will stop reading out these words. That paper never made it to the President. So I'll blame neither party on this one. But the Chief did try to fix the situation. So anyway, lest there be any doubts that he was actually the President, they did a do-over the next day at the White House. So he said the oath of office again, lest there be any doubts. Now, I'll give you another bit of trivia. President Obama shares a record with FDR as the only president to say the oath 4 times. Why 4 times? The first time for real, the second time a do-over in 2009. Fast forward to 2013. The Constitution says inauguration's on January 20th, right? January 20th fell on a Sunday. You can't get inaugurated on a Sunday. So the president got one oath on a Sunday and then another one on the Monday. So he's taking the oath of office 4 times. The Department of Defending the Constitution hasn't perhaps set in too much, but at least he's read it, right? This is my usual shtick. I've given this talk probably 60 times, so this is a little bit enjoyable for me now. So we come to this major accomplishment first term, which was the Patient Protection and Affordable Care Act of 2010. PPACA. No one says patient protection anymore. That's just dropped off. So today it's called ACA or just Obamacare. And if I may, a brief note on why I called Obamacare. First, the president himself likes that term. He was asked by Rolling Stone magazine in July of 2012, would you want historians to call this Obamacare? He said, yes, I'll be proud. So I will gladly give it that label. Also, at this point in the media, it's only called Obamacare. Even people support it. So that's the term, better or worse, that's what it'll be called. But the question about Obamacare wasn't just whether it was good or bad policy, which is far afield from what I want to discuss with you today. But the question was this constitutional? Did the president have the power? I'm sorry, did Congress have the power under Article 1 of the Constitution to implement the Affordable Care Act? Okay. So in order to discuss this, let's talk about the history of this law. And I want to talk about a social movement called the Tea Party. Okay. The Tea Party kind of sprung up in the late 2008s, early 2009s of somewhat dubious origin. We don't really know where they came from. We don't really know where they went, but they were there. And they had a big deal for a couple of years. And their entire essence was grounded on Obamacare. And they didn't just argue that Obamacare was bad policy or that we shouldn't have it. They made a much stronger argument. They argued that it was unconstitutional. Okay? Why is it significant to call something unconstitutional? Why can't they just say it's bad policy? What's the difference? Well, in our history of laws, various social movements have seized the higher power of our Constitution to give credence or significance to the social movement. So one of the first examples were the abolitionists. Frederick Douglass, a freed slave, said, look, I'm reading the Constitution, right? The word slavery is nowhere in this document. It can't even use the word. From this, he argued that slavery was unconstitutional, right? Go to the suffragists, Susan B. Anthony. Susan B. Anthony said, listen, I have the 14th Amendment. It says equal protection for all persons. It doesn't say men. It says persons. She went to the ballot box and said, hey, give me a ballot. I'm a person. And they gave her a ballot box. They gave her a vote. It was subsequently reversed because the law at the time in New York did not permit women to vote. But you have these groups seizing on the Constitution. Go look at the Civil Rights Movement. They look at the 14th Amendment saying equal protection. Separate is not equal, right? So when you make a constitutional argument, it has a higher register, if you will. It takes on a greater salience. So the Tea Party wasn't just saying we hate Obama and healthcare is bad and all this other stuff. They were saying that for sure. But for our purposes, they were actually making somewhat sophisticated constitutional arguments. I went to a rally. I wasn't attending, but I was in DC that day on March 23rd, 2010, which was in the day Obamacare passed the House. And I saw a guy holding up a sign. And that sign said, overturn Wickard v. Filburn. Overturn Wickard v. Filburn. I didn't even know what Wickard v. Filburn was when I went to law school. I mean, until ConLaw, I'd never heard of the case. We have these people who are not sophisticated saying, this is wrong. Okay? And the Tea Party grew largely around Obamacare. And it grew, and it grew, till there were marches on the tens of thousands of Washington saying, we need to stop this bill. We need to stop it. Unfortunately, the time to have stopped Obamacare was the election of 2008. Once the Democrats had 60 votes in the Senate, it was impossible to stop this, right? Because you don't have 60 votes, there's no filibuster. And because there's no filibuster, the bill can be passed with very little debate. Okay? So this was it. This was the patient protection and affordable care. Sorry, this was the first page of it. Does anyone know how many pages the actual bill was printed out? It's about yay high. You want to take a guess?
500?
Nah. Keep going.
That's 1, 2, 3. That's like 1,500.
About 3,000.
Oh, no.
About 3,000 pages, right? Which no one read, of course, right? So the final, no one read it. So the final bill was introduced in the Senate on December 15th, give or take, 2009. And the Senate Majority Leader Harry Reid said, you know what? We need to vote on this before we go in for Christmas break. That way we can bring back this vote to our districts, say, look at these great things we did, and also start the process. Listen, we're past this early version of the bill in the Senate, send it to the House. Let the House debate it for a bit, send it back to the Senate. Let them debate it a bit, fix it up, send it back and forth. This was a process that was meant to take probably several back and forth, right? So I'm going to make one point very, very clear. The version of the bill that passed the Senate on December 24th, 2009, that no one read, they admitted they hadn't read it, was not supposed to be the final version of the bill. It was a draft. There were lots of bugs. and errors and things which people probably didn't want very much in there. But they said, you know what, let's take this vote now, no biggie, and we'll let the House do all the dirty work, right? Senators don't want to get their hands dirty. But then something very funky happened. A few months earlier, Senator Ted Kennedy, a prominent liberal senator from Massachusetts, had died. The governor of Massachusetts appointed someone temporary in his place, and that person voted on December 24th for this draft bill. January 2010, a special election was held in Massachusetts to replace Kennedy's seat. Who won? Scott Brown, a Republican. So I don't want to put too much of a fine point on this, but I want to make it very clear. A Republican won in Massachusetts to replace Ted Kennedy on the sole promise of being the 41st vote to stop Obamacare. He ran in Massachusetts on the promise of stopping Obamacare in the Senate. Because once the GOP had 41 votes, they could filibuster and kill Obamacare. Done. When Scott Brown was elected, the White House panicked. Okay, the reason why they panicked was they thought this was a done deal. They had 60 votes. But now, the draft bill they sent the House had to be the final version. Because any changes made in the Senate would have to be, any changes made in the House, we sent back to the Senate and killed by a filibuster. We studied bicameralism presentment in Chadha, right? Both houses have passed the same bill, and the president signs it. So what happens if, the Senate passes version A and the House passes version B? Can the president sign it? No. That violates bicameralism presentment. So there's this massive 3,000-page bill, which nobody read and was never meant to be the final version, had to be the last deal. This is what we're stuck with today. This is the law we have today, right? And there's a case next Wednesday, King v. Burwell. I'll be back at the Supreme Court for that next Wednesday. I'll be back here on Thursday to tell you all about it. That case involves a provision in the ACA that had it gone through the normal editing process, maybe it would have been gotten rid of. But there's actually some words in the ACA that say, unless your state establishes an exchange, you don't get any subsidies. So for example, in Texas, which did not establish an Obamacare exchange, some of you may be receiving subsidies, but those are probably illegal because the statute does not provide for them. Again, this is a bill that no one read past the 11th hour on Christmas Eve that was not meant to be final. And anytime we discuss the ACA, I'd like you to keep that in mind because it's an important point. Anyway, so what happened, right? What's the history here? Well, the Speaker of the House, Nancy Pelosi, said, all right, well, we're kind of stuck here, right? We have to pass the Senate bill or else we'll have nothing. The problem was the Senate bill wasn't very good. There were a lot of things that were wrong with them. Here's a nice picture to give you a sense of scale, right? And the people in the House wanted to change various aspects of the Senate bill. Wait a minute, Josh. Didn't you just say if they change any aspect of the bill, it would have to go back to the Senate and be filibustered? How is this possible? Well, the House came up with this process called reconciliation. What's reconciliation? Well, generally when you're passing a budget that's very complicated, right? You have to make very small technical amendments. So say the House makes a finance bill and the Senate has some other amendments, right? Reconciliation exists to make sure that you can go back and forth and make small changes without a filibuster. Because it doesn't make sense to filibuster a massive budget when there are very small discrepancies. So this is how reconciliation has been used. So the Democrats said, I got an idea. Let's use reconciliation to make changes to the Affordable Care Act. So rather than making these small budgetary changes, they made these massive rewrites of the ACA. So effectively, the House voted in a version of a bill that never existed, right? That bill didn't exist. And then the Senate voted on the same bill absent a filibuster. So through this reconciliation process, they were able to evade the filibuster. I'm not a parliamentarian, but as far as this goes, it's quite dubious whether it's even out of order or not. But again, they got it done. So the House, March 23rd, 2010, I remember the day well, I was actually on Capitol Hill that day, passes the Affordable Care Act. I want to draw your attention to two numbers. First, that 0 right there. Not a single Republican voted for this bill. You know, as often said, the GOP has voted to repeal the bill like 50 times, I've lost count, right? From the get-go, virtually half the country opposed this bill, and public opinion polling shows it's never peaked above 50% popularity. Understand that this bill was pushed on the Republicans basically in a really bizarre manner they resented. And this has poisoned the well for logical legislation. I think I would argue, on a personal note, a lot of the animosity we have today stems from this vote, the fact that it happened, that they bypassed a filibuster with this reconciliation process. Another point I want to stress is this one, that 34 Democrats voted against it. Again, this was not a wide-ranging popular bill. If you go back in American history and you study a number of very big bills, Social Security, Medicare, Medicaid, Americans with Disability, right? These are these massive pieces of legislation. Go and count the votes. They're all bipartisan. They have support on both sides. This was unprecedented for a number of reasons, one of which was it was the most significant piece of legislation in modern history that had purely one-party support. That, my friends, is a recipe for disaster, right? The idea was, let's pass it and worry about the problems later. Well, here we are 4 years hence, 5 years hence, and it's still morass. Congress shut down over this last year, and people still want to repeal it in its entirety. I don't think it's going to be repealed. It's not going anywhere. But the animosity makes it a very hard piece of legislation to improve upon. Okay? I think I discussed in a previous class how there were efforts to postpone or delay, and the president threatened to veto it because he didn't want any changes made to the ACA. So here we have it. Okay? So it goes to the president's desk to sign. Everyone looks so happy. A cool historical footnote. So see how there's an entire row of pens here? He uses 23 pens to sign the signature. So he draws like a little bit, you know, he keeps switching pens, and he hands these pens out as souvenirs. It's a cool little trinket. But shortly after the president signed the bill, he made a comment to the effect of, the debate over healthcare reform is over, right? The debate over healthcare reform is over. This proved not to be accurate, as it turned out, because the debate over healthcare reform was actually just getting started. And it involved, of course, the United States Constitution and whether Obamacare was constitutional. So here we're going to start talking about some case law, okay? This was my introduction, my prelude, if you will, to the main issue. So we've discussed in this class a number of important Supreme Court decisions regarding the Commerce Clause, the Necessary and Proper Clause, the taxing power, and the spending power. Okay, Obamacare was a perfect storm for constitutional law. There was a First Amendment issue. We could just write an entire book about it, right? But it had Commerce Clause, Necessary and Proper Clause, taxing power, and spending power. Virtually every aspect of your ConLaw casebook is in here. And this case changed a lot of stuff. So where do we start? 1941, Wickard v. Filburn, right? What was this case? Farmer Filburn. See? That's him, growing his wheat. He had a farm in Ohio. He said, I want to grow wheat for myself and my animals, my livestock. I will never sell this wheat. The evil, ominous Claude Wickard, with his charts in the background of production schedules of rice and wheat, says, no, no, no. I decide the correct kind of wheat, not you, Farmer Filburn. If you grow too much, I will penalize you. This was a new deal. People were starving, so they tell farmers not to grow stuff. I mean, it makes perfect sense, right? So Supreme Court took this case. Could Congress regulate wholly intrastate farming and agriculture? What did Justice Jackson, Mr. Youngstown himself, say for the majority? Yeah. Even if his activity individually has no meaningful effect in interstate commerce, in the aggregate, this class of activity would have a substantial effect in interstate commerce. And that was a test from this case, right? You aggregate all these classes of activities together, and this will have a substantial effect in interstate commerce. Okay? This was the furthest ranging expansion of commerce power in American history. Okay, this was the literal Commerce Clause, which somewhat shredded apart sections of Article 1. But we move forward to cases in 1995 and 2000, which were Lopez and Morrison. Okay? Lopez was the gun-free school zone case. This was in San Antonio, not too far from here. Second case was United States versus Morrison. That was a case in Virginia Tech. In the first case, the Supreme Court said that the simple possession in a school zone is not an economic activity. Maybe buying a gun is an economic activity, or shipping a gun is. Merely possessing a gun is not an economic activity. United States versus Morrison, the court similarly held that domestic violence is not an economic activity. It may have some sort of impact on people and sad and whatever, but that's an aspect of the state police power. Okay? We move forward to the case of Gonzalez versus Raich, 2003. Remember, Angel Raich suffered from an advanced form of tumors, and the only palliative care that helped her was marijuana. Under California law, marijuana was legal for medicinal purposes. Under federal law, it wasn't. The feds raided her place and took her pot. She sued and said, you can't do this. You cannot regulate locally grown marijuana that I bought at Whole Foods and was tendered and cared. No, you can't regulate local marijuana that was grown where the seeds have never left state lines. The plant was always in California, and this has no impact because there's no marijuana market, right? This isn't like the agricultural case where you had a wheat market, a nationwide wheat market. He said, listen, I'm just growing some local weed. I'm not bothering anyone in any other states. This case was argued by my friend Randy Barnett, who wrote the foreword for my book, and he didn't win. So Angel Raich, this is actually a picture of her finding out that she lost the case. It's a very moving photo. But what did the court held there? They said, okay, look, yes, having marijuana in one state isn't really affecting interstate commerce, but Congress has an interest in prohibiting drugs, right? There is an interstate drug market. And if Congress wants to shut down this interstate drug market, as a necessary and proper incident to that power, they need to criminalize medicinal marijuana. They can't go around stopping the war on drugs if all these people are growing local pot, right? That can't happen. So Raich wasn't so much a Commerce Clause case as it was a necessary and proper clause case. And Justice Scalia made this point much better than Justice Stevens. He said, listen, there's no way that Congress can have the war on drugs, which we think they can have, if they let this local marijuana go. The entire thing will fall apart. Okay? So we have wheat and weed, right? Or grain and ganja. You can tell I've done this before, right? So it's automatic. So you get the comment there. It's like, Mystery Science Theater 3000. You get the, I can comment on myself. So this brings us to Obamacare. Now, if you had asked me in 2009, Josh, could Congress pass a law requiring people to buy health insurance? I would have told you, yeah, why not? So Josh, how can they do that? I'm like, well, you have Wickard and you have Raich, which says Congress has some sort of interest in a national healthcare market. In order to make that healthcare market work, you need to have people buying health insurance so that they're in the market and they're paying money to it. Right? Why is that such a big deal? Okay. This is where constitutional law becomes fun. Because when the president does something, you ask yourself, has this ever been done before? And in my own naive sense, and this is what I actually said in 2009, yeah, this is just like Wickard and Raich, right? It's regulating an economic market for health insurance. But this is where the genius of people like my friend Randy Barnett and others come in. They can see the case differently. So follow me here, right? In every single case that we've discussed, Wickard, Lopez, Morrison, Raich, in those four cases, the court over and over again speaks of economic activity, classes of activity. I promise you, if you go back in your notes and you look in the cases, you'll find that over and over again, the court speaks of economic activity. Okay? Of course, Congress can regulate economic activity. Is Obamacare a regulation of economic activity? Well, you're shaking your heads now, but I promise you if I'd asked you this question in 2009, this question would never have occurred to you, right? And I think I mentioned this story once before, but there was a law review note written by a student at Case Western Law School in Cleveland, Ohio in like 2004 or 5. And he made this comment saying something like, well, in Raich, Justice Scalia kept speaking of classes of activities, right? What if Congress is trying to regulate something that's not in a class of activities? Could Congress do that? And he didn't know anything about Obamacare. Obamacare was a glimmer in his eye. It was 6 or 7 years away. But that single note, which was known by some DC lawyers who I work with, came back and said, wait a minute. classes of activities. If Congress can regulate classes of activities, what happens if Obamacare falls outside of a class of activity? This was a stroke of genius of how to frame this challenge within Supreme Court cases. So rather than saying that this case was governed by Raich and by Wickard, you can now say it's not governed by those cases, that it's different, that it's distinguishable, that it's unprecedented. And this is where we begin. By framing the issue in a way that was not consistent with precedents, the challengers were able to actually make a constitutional case, right? Had this case been argued under Raich and Wickard, they would have lost. If they went to Supreme Court, yeah, overturn Raich and Wickard, go for it, guys. Okay, they lose. But they say, this is consistent with Raich, this is consistent with Wickard. You need to overturn nothing. So I'll give you a pro tip, right? If you ever go to a court, your answer should never be, judge, overturn that case, right? That is never your answer. Your answer is, judge, this is consistent with this case if we interpret it like this, right? Unless you're in the Supreme Court of Texas or the United States, don't ask to overturn precedents. Not a good idea, because you're going to lose. I mean, courts can overturn precedents. They're bound. I mean, they can't. But even the Supreme Court doesn't like to. So we go to this, the broccoli horrible. At one point, I briefly considered making the cover of my book a piece of broccoli. I'm glad I didn't do that. But I have the mock-ups I can show you. I actually designed it. It was stupid. But for like a 24 hours, I thought it was a good idea. It was not.
Is that before or after?
Before. Although after it made less sense. So why is broccoli the defining image of Obamacare? Well, the way the Affordable Care Act works is like this. A lot of you guys are young and healthy. Maybe you don't want health insurance. Maybe you say, I don't need it. It's too expensive. And you say, you know what? If I get sick, I'll go buy health insurance, but for now I'm fine. Well, before Obamacare, say once you get sick, the insurance companies can charge you more money. This is what was known as charging higher for a pre-existing condition. If you come into the insurance policy with some sort of sickness, say diabetes, whatever it is, right? They can charge you more. It's a form of price discrimination, similar to how if you have a bad driving record, you have higher auto premiums. I mean, this is generally how things work, but insurance companies are based on actuaries. Okay? But this is considered unfair, right? How can we punish people who are sick by charging them more money? So a number of states implemented laws saying, insurance companies, you can't charge Josh more money if he's sick when he comes into your market. Okay? Okay, so they can't charge it. So what happens then? Well, the insurance companies aren't stupid. They have to recoup their losses somehow. So they charge everyone else more money, right? If they have to deal with all these people who are have very high costs of sicknesses, they raise rates. But even more so, here's what happens. If I know that I can go and buy insurance at any time, why don't I just wait till I get sick? Why don't I just pay stuff out of cash now? And then on my way to the hospital, I go on my iPhone and order, insurance. I'm exaggerating slightly, but that's the idea. Okay? This way, you don't have people paying into the system because it's too expensive, and people only join it when they're sick, which has the highest cost for insurance companies. You see, this creates what's called an adverse selection death spiral. Sounds like a rock band, but it's a very serious situation where the only people in the market are sick, and all the healthy people are sitting on the side waiting and not paying into it. This results in your state going bankrupt. Massachusetts tried this, and it failed miserably. So as a result, Governor Mitt Romney, of course, a Republican, implemented what became known as Romneycare, which said, I have a free market way of fixing healthcare prices. Rather than having single payer, I will simply mandate that people buy some minimum level insurance. This way, everyone's paying into the system. They're not going to only join when they get sick. What happens if someone doesn't pay into the system? They pay a penalty, which covers their costs, right? You may analogize this to if you don't have a car insurance, you have uninsured motor fee. You know about this? In the same ballpark, right? So you can compensate for others who are injured. This was an idea in Massachusetts. Ted Kennedy worked on it, as did Jonathan Gruber, our favorite. This was his idea. So we have now the question. The states can do this under their police power. The states can require inoculations. They can require schooling. The states have various powers to require you to do stuff. That's the police power. But what about the federal government? In our system of enumerated powers, as Chief Justice Marshall wrote in McCulloch v. Maryland, the enumeration presupposes something that's not enumerated. In other words, the fact that Congress listed 23 powers means that everything not listed there is outside the scope of their abilities. The fact that we have Article 1, Section 8 means that there's some stuff Congress cannot do. Okay? Can Congress require you to buy health insurance, and if you don't, stiff you with a penalty? Okay? So why broccoli? All right, what's the image of broccoli? Well, initially it was a gym membership. That was the first example I heard, but it evolved into broccoli. Actually, it was a gym membership, then Brussels sprouts, and then they stopped on broccoli, which I think was the most potent image. Okay? This is actually a picture from Wikipedia. I know this. I actually spent 3 hours looking for different pictures of broccoli for my cover. Anyway, this one's from Wikipedia. So why broccoli, right? Well, if people buy broccoli, they'll be healthier. They have low cholesterol. And, you know, if they eat the broccoli, their health insurance costs will be less. So why don't we just make people eat broccoli, and we'll lower healthcare costs and everyone will be happier, right? This is what we call in law a slippery slope, right? If Congress can do X, oh my God, then they can do Y, right? If they can make me buy health insurance, oh my God, they can make me buy broccoli. But I think a better way of looking at this is in terms of a limiting principle, right? This is what lawyers use, not slippery slope, limiting principle. The government has the question to decide. If we can make you buy broccoli, right? If we can make you buy broccoli, what's to stop us from making you buy something else, right? Where do we limit you within the precedent? Or to use an example involving General Motors, which at the time was owned by the United States government, right? If GM's bankrupt, could we make you buy a GM vehicle for your next car? Penalize you if you don't. Why not? It helps the United States economy. It's good for General Motors. It's good for the United States, as they once said. Perhaps not anymore. So these are the constitutional questions. And I bring you back to the president's signature, March 23rd, 2010. And if you look carefully, see the O is very jagged and rigid? That's because he used 5 different pens for the O. Apparently his practice hasn't gotten better. This one wasn't very good, but the O is very jagged. That's the reason why. So what happened after the president signed the Affordable Care Act into law? It was a race to the courthouse. And I mean a race. Before the ink was even dry, within 17 minutes, lawsuits were filed across the country challenging the individual mandate. And actually, 2 aspects were being challenged. So the first one was being challenged by a number of individuals, saying the individual mandate requiring you to buy health insurance is unconstitutional. That Congress lacks the power to mandate activity. The second aspect, which is much less known but perhaps more important, involved Medicaid. Okay, so I'll give you a little background. Everyone knows there's Medicaid and Medicare. Medicare is for senior citizens. And the way I remember that is R, retired, right? Medicare is for seniors. Excuse me. Medicaid is for poor people, people at the poverty line. So the way Medicaid works is that the federal government gives lots of money to the states, and the states then administer Medicaid. So there's no national Medicaid program. States administer it. Okay, so if you want Medicaid, you have to go to a state office, more or less. But as we know from our spending power cases, like South Dakota v. Dole, there's no free lunch. When Congress gives you money, they put strings on it, right? When Congress gives you money, they put strings on it. So the Affordable Care Act did work like this. They said, all right, as it stands now, you have to give people Medicaid at the poverty line. We want to expand it. We want you to give Medicaid to people who are at 133% of the poverty line. The federal government will pay virtually the entire cost of that for the next few years. And probably thereafter, though it's not a promise, but a guarantee, right? So one state, Arizona, sent a letter to the federal government saying, hey, wait a minute. What happens if we don't want to expand Medicaid, right? We don't want to incur these costs. Can we just keep our existing money? And some low-level wonk in HHS, who probably didn't know what he was doing, sent a letter back and said, hey, Arizona, that's nice. If you don't accept this new money, we will take away your entire Medicaid budget. All of it. I mean, it's in the billions for a lot of states. Okay? If you don't expand this, we will take away every penny of your budget. You can't even keep the old money. You have to take it all or nothing. Okay? So you remember it's in the reading South Dakota versus Dole, right? This was the drinking age where Congress said, hey, South Dakota, if you raise your drinking age to 21, we'll give you some highway funds. And if you don't, we'll take away some small chunk of your highway funds. Okay? The court said, oh, that's fine. We're talking about, a few $1 million here and there. What's the big deal, right? Here, states stood to lose billions of dollars, billions with a B, and basically put, hundreds of thousands of people on their Medicaid rolls, in the case of Texas, for example, on the street because the state could not afford it. So the states argued, wait a minute. This is not a choice. This is coercion. You are forcing us to accept this new program at the threat of taking our old money. Now, the spending clause is always weird, right? How can it be unconstitutional for the federal government to take money away? Right? They have no obligation to do so in the first place. But the doctrine's developed to the point where states can't be screwed over, to put it mildly. They view this almost in terms of a contract. And when you have a contract and you have certain terms, you can't add new contracts and put them in a bad place, right? For example, put an analogy, federal government and the states had a contract for Medicaid, and they were doing this since the 1960s. All of a sudden, the federal government said, oh, we want to add some new terms, and if you don't comply with these new terms, we'll just breach the old contract, we'll void it. Right? That's not usually allowed. You have to negotiate for the new terms. So the state said, there's really no meaningful choice here. We have to go along. We're being coerced. So lawsuits were filed. There were two main lawsuits. One was filed by an alum of my law school, the former Attorney General of Virginia, Ken Cuccinelli, who recently lost in the governor race to Terry McAuliffe in Virginia. He was a maverick. He decided to file by himself, and he filed a lawsuit in Virginia. And remarkably, he won. He was actually able to convince a judge, Judge Henry Hudson in Richmond, that it was unconstitutional for Congress to compel individuals to buy health insurance. The president was not happy about this. The law remained unpopular, and courts now were starting to invalidate it. But the main event was in Florida, in a small town named Pensacola. This is Judge Vinson. And Judge Vinson had a challenge before him on behalf of 26 states. If you're sensing a pattern, it's virtually the same 26 states that are challenging the immigration law. One fascinating aspect of the recent years of litigation is you have these massive statewide challenges, right? Why are the states bringing the challenges? In their mind, they're actually representing the interests of the sovereign of their people, right? So Florida took the lead, joined by 25 other states. There's some interesting backstory where Texas wants to do it, Florida filed first. It's actually then Attorney General Greg Abbott got beat on that one. He was too late to the pack, so Florida was well ahead of it. You can read about this in my book if you want the history. So this case, again, had the two issues. The National Federation of Independent Business were a group of small business owners, and they said, we cannot be required to buy health insurance. This is unconstitutional. The state of Florida argued that this was unconstitutional, that we can't be coerced to expand Medicaid in this fashion. Okay? So I want to take you back to 2010. I was in my first year of clerking then. And when I first heard about this challenge, I was present when this challenge began. It was hatched in a ballroom at the Mayflower Hotel in Washington, D.C. in November 2009. I was there. People said, hey, Josh, you want to help with this? I'm like, sorry, I'm clerking. I can't. But I followed it very closely. I kept a distance because I was clerking, but I was following it. I thought, there's no way this works. If you were to ask virtually any constitutional law professor in 2010, was this law unconstitutional? The answer would have been, of course not. This is ridiculous. This is governed by Raich and Lopez. There were these letters signed by hundreds of law professors saying this was constitutional, right? Every law professor in the country, except for like 5, agreed this was unconstitutional. So what the heck happened? What changed? Well, there was a serious effort by professors like Barnett and others to change ideas in law review articles, op-eds, media appearances. But what really brings the argument from off the wall to on the wall is when a judge accepts it, right? Law professors like saying crazy things. I'm very good at it. I see lots of crazy things that no one listens to, even Congress, right? But when a judge who was appointed by the president, confirmed by the Senate, takes a stand and accepts an argument that something violates the United States Constitution, that makes it real. I see lots of parallels between Judge Vinson and Judge Hainan in Brownsville, right? People thought this argument was stupid. Judge Vinson wrote, it was over a 100-page opinion explaining in great detail why this is unconstitutional. When I was reading Judge Hainan's opinion, I had some of this deja vu. I've been here before. They had a judge in a little town that no one knew much about that put a serious effort to understand a tough issue and find that the president acted unlawfully. So Judge Vinson found that not only was the mandate unconstitutional, but the entire ACA was unconstitutional, the entire thing. Okay? President, not happy. Because even though a number of judges had upheld it, 2 federal judges in Virginia and Florida had invalidated the ACA. Okay? So off to the courts of appeals we go. By the way, unlike in immigration, which might be over and done with in 6 months because of the expedited nature of the appeal, this took almost 2 years. Right? Complaints were filed in March 2010. SCOTUS heard arguments in March 2012, and was resolved June 2012, a day I will never forget. Okay? So most of the appeals are argued by, this is the acting Solicitor General, Neil Katyal, and this is Republican Wunderkind, Paul Clement, who's probably the greatest Supreme Court advocate alive today. People may disagree with me, but he's the best. If you want to listen to the best Supreme Court arguments, go listen to his argument in the Obamacare case. Go to oyez.org, O-Y-E-Z, and bring up his argument in the Obamacare case. Magical. He was in the zone in a way that I hope one day he's a lawyer to ever actually be, but I probably will never be. But he's good, that good. No notes, by the way. He goes up to the Supreme Court, no notes. It's a sight to behold. So we have here again the first appeal to the Sixth Circuit Court of Appeals, where I clerked. I got there about 3 months after this case was decided, so I had no involvement with it. And in this appeal, Judge Jeff Sutton, who was a prominent Georgia Bush appointee, upheld Obamacare. So people are saying, oh, wow, this is great. You know, we have a Republican appointed judge who upholds the law. You know, see these dumb judges in Virginia and Florida, they know what the heck they're talking about. Well, you know, this is my happy Obama picture. He's very happy there. But then we get to the main event, which is a Court of Appeals for the 11th Circuit in Florida. Okay? The Court of Appeals, 11th Circuit in Florida. I'm sorry. The 11th Circuit's in Atlanta, but the appeals come from Florida. Sorry. I caught myself with that one. This one was the 26 states that were challenging the ACA. Remarkably, in an opinion by Judge Frank Samail, and Joel Dubina, the court found that the mandate was unconstitutional. Okay? Why is this so significant? Because now we have a circuit split. And as I'm sure you've studied, generally one of the key factors for the Supreme Court to take a case is a circuit split. And in the absence of a circuit split, this case wasn't going anywhere. I made a prediction in New Year's Eve 2009. Stupid. I said, I think these are my almost quotes. There's no chance the Supreme Court gets near this with a 10-foot pole. I thought this challenge had no chance of getting to the court. I was wrong. See, I don't make predictions anymore. If you ask me, I won't make a prediction. People on the radio, Josh, what do you think? Oh, I don't know. So I don't make predictions. I'm always wrong. I wish more people said that. They're always, predictions are bad. So the president said, this is my stop Obama picture. We have to stop these cases. So the next appeal, I'm going to need to bore you with tax law. So, and I'll be brief, I promise. It'll be painless. So as I'm sure you know, we're now at the end of February. You'll soon have to pay your taxes, right? So what happens if the IRS assesses you with a tax and you disagree with it? You say, oh, no, you messed up. Like, you didn't calculate this right. I have this deduction, right? Can you go to court and sue? The answer is no. You have one option. You pay the fine, and then you go to court to seek a refund. You pay the tax, and then you go and seek a refund in court. The reason why is something called the Tax Anti-Injunction Act, AIA, Tax Anti-Injunction Act, which unfortunately they cut this part of the book out of your opinion, which drives me nuts because it's the most important aspect of the case. Who'd have thought that the most important aspect of the Obamacare decision was a Tax Anti-Injunction Act? Yeah. Still, every time I read this case, I'm still surprised at the ending. I was like, did it really end this way? Anyway, So what does the Tax Anti-Injunction Act say? If you don't like how a tax is assessed, pay it and seek a refund. Okay, so what about Obamacare? Well, as we said before, when Obamacare was being debated, everyone said that this is a regulation of interstate commerce. They had constitutional findings saying this is a regulation of interstate commerce, Wickard and Raich done. But once the government got to court, they raised another argument. They said, oh, wait a minute, this isn't a penalty, this is a tax. Now, the president was asked many times during the debate, is this a tax? He said, no, it's not a tax. Sensing a pattern here. Can you grant deferrals for millions? Oh, no, I can't do it. Oh, no, now I can, right? Is this a tax? No, it's not a tax. Oh, it's a tax. So, again, I think this is an episode of bad faith, but when this law was being sold, it was sold as not a tax. Why? Because imposing taxes are unpopular. No one likes taxes, and the president taking a pledge not to raise taxes. So he consistently said, this is not a tax, this is not a tax, this is not a tax, this is not a tax. Up and down, I can give you quotes, right? The second they got to federal court, oh, by the way, it's a tax. Why, though? Why did they assert that it was a tax? Well, as if we studied, the taxing power is much broader than the commerce power, right? Even though the commerce power is broad, you can only regulate interstate activity. The taxing power, you can regulate anything, even wholly within one state. It doesn't have to be economic activity. You can tax possession of land, all right? You can tax possession of goods. So the government raised this argument to save the law. But who would have thought that this would be the argument that saved it? Anyway, we have one more Court of Appeal. So this is Don Verrilli, the Solicitor General. And the final Court of Appeals to consider this was the DC Circuit. And an opinion by Judge Brett Kavanaugh, who was a Bush appointee, he had one sentence as an opinion that was very interesting. He said, well, you know, it's not a tax. Let's be real here, right? In the statute, it's called a penalty. Everyone debating it said it's not a tax. So it's not a tax. But if it were a tax, if we just tweaked the statute, but we rewrote it, this would be a perfectly fine statute, right? Congress could have done this with the taxing power. Okay? If we just tweak it a little bit, we can save it. This would prove to be the basis of how the law was upheld. All right, let's take like a 10-minute break. Come back at 6:40, please. Okay, thanks. Okay, don't worry about it.
I was totally researching in the library and I forgot that I closed.
That's okay, don't worry about
I'll ask John. I didn't think it would cross, but actually, I saw Patrice today. Went down to Patrice office showing that clip, and she was like, "So, is that the progress?"
No. But Carlson was observing. Professor Carlson. Future evaluation time, I guess. No, I have no idea. And and then so you probably, let him get out of here. And he's probably need to go.
Yeah.
Yeah. I wonder how many staffers sat through that whole thing. I've been this year. And those hearing rooms, yeah.
No, that's sad.
You know what's sad? My life right now is sad. Working a job I hate, going to school all the time, going after a profession that will never, in which I'll never earn back the money I invested.
Stop.
and I'll lose like 3.5 years of my life and my family. And I'll never have a solid bond with that child because I wasn't there during his formative years because I was here every night. Well, I will be there. Because I'll toil away at a job, sock money away like it can. But barely. But
Your son
barely.
will appreciate that.
I'm gonna spend every dime. He won't see that. I'm only having one kid because I don't want my I don't want my children fighting over who's gonna pay for the nursing home. It's solid. He's doing it. He's the one.
Come on, he's so cute.
Yeah, right. And he can earn plenty of money as a male stripper or something and pay for my nursing home.
Well, yeah, I guess.
But you can.
What's that?
So y'all are.
And they're like, they're against.
Not my position. We may have.
Yeah. But no, it's.
But if I adopt, I don't want.
Right.
I want to adopt
I think it's like a really good history.
because I want him out of the house sooner.
We'll let you air your frustrations to us, but we just play right these things. I should hear that all. I know. I feel a lot with my dad. Like, my dad always makes me.
It's not in. I always said I was gonna like scout out the foster homes during like football practice. Determine like who's gonna.
Who's gonna work with me?
Yeah, who do I need to adopt to secure my financial future?
Okay, so that's being blindside.
Oh yeah, I said that long before I go around. Someone who's already got letters in college.
Well, I was just gonna look at the case itself.
Yeah, no, but there's
Are there, I'm sure there's a lot.
All my kids are in the same time, and I was like, got it. Yeah, and I was like, I'm sure probably that they have scholarships of some sort.
Yeah. I'm not paying for my kids' college. You're gonna go to community college for 2 years. Actually, he's gonna join the military for 2 years.
Jeez.
Then he's gonna get out. He's gonna have a GI Bill. He's gonna go to junior college. Yeah. He's gonna get all the girls because he'll be tough shit because he's 2 years older and he'll have a uniform hanging in his closet. The 18-year-olds love that.
What if he's like a Jason? Your son moved for your house. Yeah. What if your son's super smart or super athletic?
He's my son. He's not gonna be super smart or athletic. Unless he's not my son, which is like a 50-50 chance.
What if he's like real athletic?
Right.
Turns out
Then we
he's
got
like really muscular.
Then we got like extra questions.
I can imagine also the
Then I need
Professor is literally like.
Exactly.
Except for.
I turn to my wife and I go, "We need to talk." That was awesome. You drained that 3-pointer. We need to talk. What were you doing?
That coordination.
What were you doing this weekend 16 years ago?
Yeah.
300 page, or $300.
CLEN.
I can't remember, it was great, but 250.
I was studying in the library. See, another reason law school was my life.
Yesterday. Yeah. She felt bad.
Yeah, We found out she was pregnant and that I got in law school at the same week.
Because it's
I mean, that woman is the same.
cases that have been.
What'd you say? I couldn't hear what you said.
Do they not show cases that
No, they only show from previous years. If you go to the Supreme Court's website, you can see the current cases.
Well, I was just gonna ask you real quick,
Okay, so my kid was born at the end of October.
based on what we were talking about in our meeting,
So dealing with those Oklahoma botched executions. So this guy Charles Warner tried to go before the Supreme Court.
Yeah, he was executed.
And they denied the stay, and then apparently four of the justices dissented, so it's 5-4. Sotomayor she's talking a lot about what I'm talking about, or I see kind of her argument there. So I'm thinking I could probably use some good stuff there as far as like recent, because after I left the office, I looked at Blaze v. Reagan. I don't think that there's anything when I looked at that one. I'm not sure that there's Supreme Court after that one.
Okay. Yeah, you need to find something. And if you,
But how do I find if that's that recent?
You know what?
Not gonna be on
You know what? Try writing the first part. Try actually figuring out the first part. Could Congress do it? And then if you get that far, then you can see if they want to do part 2. That might be a better idea because you're going to scramble so much. Try and see if they could do it.
So you mean as far as just addressing Fifth Amendment cases, addressing Byrne, and then
Actually try and fully outline that part and see how you do, and see if that's ambitious enough. Then you can maybe stop there, or that might actually lead you to the other part.
Okay.
All right, we'll get started.
Thank you.
So
Yep.
she got in and I got in Dallas. So I got assigned to VA.
Yeah, and I lost the track.
All right, welcome back, guys. All right, I think we might have one less. So just so you know, the way this works for the law school is that we're required to evaluate it every year. It doesn't mean I'm in trouble or anything. Just they're required to come in. Probably 2 more will do the same. Remember when I was in law school and everybody saw a professor being observed, like, oh man, but he's in trouble. So no, it's the standard way to make sure that that we're doing a good job or something like
We're
that.
still gonna assume that.
Yeah, no, I know you are.
What he said.
I could be lying to you, right?
At least it was an impressive start to the class. I mean, pretty good day to come over here.
No, he got his plug in for his refund. He's like,
Yeah.
Anyway, so let's get started. So we're at the point now that this case was before the Supreme Court to split. And the justices were being asked to decide this very important issue. And the relationship with the President Obama and the court has always been somewhat fraught. And here they are looking all happy and smiling and cheerful. But there's some history there. Actually, by the way, this is, I've discussed before, but this is called, the Justice Ginsburg, the teacup thing, called a jabbet. Remember I called it a neck doily? So I'm in Black's Law Dictionary. The alternate for jabot is called a neck doily, the slang. I actually got that word in the dictionary, so don't laugh. But inside dirt, RBG gave Sotomayor a jabot, and she stopped wearing it. She didn't like it. Ginsburg also gave one to Kagan, stopped wearing it also. So there's some dissing going on at the Supreme Court with the jabots. Anyway, this is stuff I study, right? This is I get paid for this apparently. I don't even know. So anyway, the Supreme Court has often had somewhat of a fraught history with President Obama, and this goes back to the 2010 State of the Union. Jason, you're shaking your head. What happened?
Well, the normally stone-faced justices, Justice Alito actually, he shook his head and made assertions that it wasn't true.
What wasn't true?
It was the Citizens United case that has just been decided. And
yeah. So in the middle of the State of the Union, right? Have you ever seen this? The justices have to sit there stone-faced. They can't clap. They can't applaud. You know, they can't do anything. They're supposed to sit very emotionless. Justice Ginsburg apparently falls asleep now because she had too much wine.
Yeah.
Don't get me started. Just don't get me started. If I came to work so drunk that I fell asleep, I'd be fired. Professor Carlson would write my termination letter in 5 seconds. Anyway.
She wasn't drunk. She was just not 100% sober.
She was enjoying herself.
Yeah, I bet she was. So, very notorious of her. So the justice forgot he was on camera, and he started whispering "not true" to the president's claims at Citizens United. Well, he was on camera, And Alito has not been back to the State of the Union since then. Scalia has been there in almost a decade. Thomas hasn't been there in even longer. The only people who go now are the chief and Chief's there, Kenny's there, Robert, Ginsburg, Breyer, and Kagan are usually there, and Sotomayor. So it's usually a 6-3 attendance showing. Interesting footnote: the year after President Clinton was impeached, no one came. Justice Breyer actually said he wanted to, but he was sick. I guess he was, was cleaning, washing his hair, as they say, right? But all the justices basically boycotted the State of the Union the year after he was impeached. So it was a pretty powerful statement. So we go to the Supreme Court, and as you know, there are no cameras in the Supreme Court. And the only way to get inside is to wait online to get one of 50 golden tickets. They actually are gold. They're a shade of yellow. But it's very similar to Willy Wonka, right? It's very hard to get in. To get a ticket to the Supreme Court for this case, the first person online camped out for 96 hours. You ever waited for concert tickets overnight to be the first one? Okay. You wait for Supreme Court tickets. So I've done this 3 or 4 times. I wait as long as 13 hours on the street. And I'll give you a pro tip. The sprinklers come on at 2 in the morning. So in the middle of March in Washington, D.C. in the 30-degree weather, when the sprinkles come on, it sucks. It's really bad. So
wasn't it only 96 hours because that's when the police at the Supreme Court said that they would not accept the line before 96 hours?
I don't know. That's possible.
I think they wouldn't allow anybody to get in line.
I mean, it's a public sidewalk, right? So they can't kick you off. And what's interesting is that you can't bring a sleeping bag. No, you can bring a chair, but not a sleeping bag. So I had a folding chair. It was terrible. It was really cold. I had never been so cold in my life. No matter how many layers of clothes, if you're outside without a sleeping bag in 25-degree weather, you're cold to the bone. And look, I'm a Jew from New York. I don't camp, right? So this was very uncomfortable for me. So I'll tell you a secret, which is being recorded. I've actually obtained a line waiter. So you can pay $40 an hour for someone to wait. So I've delegated this task to someone who was in my position years ago. So they're actually interns who will wait in line for me. So I got this covered. So for next Wednesday, I will be warming my bed and someone will wait in line for me. It's actually worth it. Because for one case, it was a Second Amendment case in 2010. I got there around 9 p.m. So it was almost 13 hours from start to finish. And I was dead the next day. And I had to give a talk after. It was bad. So anyway, so Supreme Court.
Do you always have to wait in line? Like, is there always a line?
If it's not a popular case, I can usually ask for tickets from a friend. But when it's a popular case, you can't ask for tickets. There's always a line, but I can usually get tickets for like a small case, but not this one. Okay, is your hand up? Yes. Okay. So the arguments in this case were broken up into 3 days, right? 4 issues over 3 days. So let's go through them. These are actually the issues in the Chief Justice's opinion. Okay. Day 1. Tax. Okay. Day 2, Commerce Clause. Day 3 was a double header. In the morning, they asked if the mandate was unconstitutional, could it be severed or separated from the rest of the law? Day 3 afternoon, was the Medicaid expansion constitutional under the spending power? This was a 5.5-hour marathon. These were the longest arguments, I think, since Roe. I might be wrong with that, but I'm pretty sure it was the longest arguments in almost 40 years. Okay? Even longer than the gay marriage case. That's coming up this year. The issue on the first day involving the taxing power was argued between, again, Don Verrilli, the SG, and Paul Clement, who I recommend you listen to his argument. Listen to his Day 2 argument. So here's the question for Don Verrilli. This is the million-dollar question, which is why this entire case turned on tax law. I said before that if there's a tax assessed to you, you don't like it. You have one choice. You pay it and you sue for a refund. Okay? So let's say Obamacare is a tax, right? When will that tax first be assessed? In what year? 2014. You have to pay in a few months. Okay? The Obamacare tax was not assessed until 2014. This lawsuit was filed in 2010. If it's a tax, how can you challenge it before you pay it, right? Wouldn't the correct decision be pay the tax and then sue for a refund? Now, why do you think President Obama didn't want this strategy to work, right? Why do you think he didn't want to wait till 2014 to have this lawsuit filed? Anyone? Yes. Why would President Obama in 2010 not want to wait till 2014? He may not be the president anymore. Imagine that. What if he had lost in 2012 and the Republican president said, nah, I'm not going to enforce Obamacare. I don't like it. Oh, you see how this works? I made that point in my testimony, right? What if the Republican in 2012 said, nah, don't like this Obamacare. You can keep your health care plan. I'm not going to enforce it. Done. They had to resolve this case now. They could not wait till 2014. But this creates a problem, right? They say, all right, it's not a tax. Resolve this now. It's a penalty. Wait a minute, though. If it's not a tax for purpose of the Anti-Injunction Act, what about the Constitution? How can something be a tax in one respect but not in the other? How, and follow me very closely, this is the trickiest aspect of the case, which most people don't understand. How can it be not a tax for the Anti-Injunction Act, but yes, a tax for the Constitution? How can the same provision, which is labeled a penalty, not be a tax for purpose of the statute, but be a tax for purpose of the Constitution? The entire case turned on this one idea, which almost no one even cared about. The first day of arguments, no one even cared. That poor woman waiting 96 hours, she skipped the first day of arguments. Like, yeah, I'll wait till tomorrow. So she actually didn't even bother going inside. This is where the magic happened. Okay? Day 2. Solicitor General Verrilli's biggest enemy was a glass of water. Okay? So I'll give you another pro tip. If you ever go up to argue before a court, and I hope you all do not drink immediately before. Because water goes down the wrong pipe sometimes. We've all had that happen, right? So the Solicitor General gets up there and he goes, Mr. Chief Justice, may it please the court. You always start that way. Mr. Chief Justice, may it please the court. And he says maybe a sentence or two, and silence. The entire room is covered by silence. He was choking. He literally could not breathe. He had done so many moot courts the week before that he burned out his breath, and he'd taken some water before he got up there, went down the wrong pipe. The biggest argument of his life for the Supreme Court, and you can't tell from the picture, but there's about 3 feet separating the lectern and the bench. Maybe it's like 3-4 feet. They're real close. Choking, literally and figuratively. If you listen closely to the audio, you can actually hear him going for a glass of water, clinking around. But this is a mark of a skilled advocate. You want to talk about advocacy? He said a few words before he started choking. He repeated them verbatim afterwards. He has an entire opening committed to memory. That's skill. After you choke before the Supreme Court, to get your stuff back in order and repeat verbatim what you said, A+, right? That's a mark of an advocate. I don't think I'll ever achieve that in my life. I can't say the same thing twice, in a minute. But in any event, though, it went downhill from there, though. So the rest of the argument didn't work very well for him, even though he got his breath back. And the reason why was because the government failed to identify a limiting principle. The justice asked very clearly, right? Under the Constitution, if the government can make you buy health insurance, why can't they make you buy broccoli, right? Justice Scalia, always a smartass, right? Justice Scalia asked a broccoli question. Justice Scalia asked, this is going to be the cover of my book also, right? Justice Scalia asked, wait a minute. In all of our cases, from Wicker to Raich, we spoke of classes of activity. Not having insurance is not a class of activity. It's inactivity. See? You're not active. You're not buying health insurance, right? How is this different? So what the government said is, wait a minute. No one is ever really inactive, right? Everyone will need health insurance at some point in their life. You can either pay for it now or pay for it later when you get sick or you get hit by a bus or whatever, right? The government argued, we're merely regulating the manner in which people pay for their health insurance because everyone will get sick. Okay? Justice Scalia responded to that is, well, that's something that happens in the future. Has a court ever held that you can regulate commerce that happens in the future? No, Justice Scalia said during arguments, you are forcing people into a commercial transaction. Now, follow me here, right? If Congress can make you engage in commercial activity, they make you buy a product, you are now in the stream of commerce. Remember that from Asahi, stream of commerce? This is where it comes from, right? You are now in the stream of commerce. And once you're in that stream of commerce, Congress can regulate you however you want. So if you think about it, remember New York versus United States? That was commandeering of states, making states take over the radioactive waste. Printz v. United States, this is the Brady gun case. States commandeering officials to make them run background checks. Here we have commandeering of the people. That the people were required to now buy a commercial transaction, and once they're in commerce, Congress can do whatever they want to them. The justice said this is a very bold assertion of executive power, a congressional power, because now the states are, the people are being forced to do this stuff. They even asked about a GM vehicle, right? Why can't we make you buy a GM vehicle? It's a commercial transaction, okay? The argument over the spending power, though, was really interesting because most people didn't take it seriously. Up until the Supreme Court, not a single court anywhere found a violation of spending power. Every single court said, of course, they can require states to expend Medicaid. But Chief Justice Roberts asked, what about Arizona? Right? What about that letter from Arizona by that low-level HHS wonk that said, if you don't expand, we'll take away your entire budget? And the Solicitor General tap danced and tried to avoid the answer, but he couldn't. The Solicitor General said, will HHS take away the money? The government lawyer said, I can't answer that question. Justice Breyer joked, is that above your pay grade? The Solicitor General chuckled, but the answer was yes. Why? Because Secretary of HHS Kathleen Sebelius insisted that she wanted to retain the power to bankrupt states who didn't comply. That's a mighty fine stick the government holds. Yes, sir.
Didn't Justin Kagan try to give him an out when she referred to like glasses? You know, if they make a small tweak to the law, let's say an administrative rule about how Medicaid pays for your eyeglasses, you know, can they take away your entire, you know, budget? And he essentially agreed.
Yeah, I mean, I'm glad you read the transcript. That's really good. Justices Breyer and Kagan were very upset about this because they were basically trying to say, find us a way to save this. Don't make us vote against this. And the government couldn't. Okay? So those are the end of arguments. And usually in most cases like this, all eyes turn to AMK, as we call him, Anthony M. Kennedy, who is often known as the swing vote, who decides whether we have gay marriage or sodomy laws or death penalty, whatever else. He usually decides these kinds of things, right? But in reality, all eyes were on the doe-eyed gaze of, I love this photo, so like, it was like a deer in the headlights, right? Of, it's pretty close to what happened, of John Glover Roberts Jr., the chief. And there was a deliberate effort on people outside the court to try to influence the court. We're seeing this actually right now with the second Obamacare, or the third Obamacare case. By the way, I'll have a piece in the Wall Street Journal tomorrow on the Burwell case, so you can take a look for that. It'll be published in Friday's paper. But the Monday after this case was argued, the president gave a press conference. Impromptu, no teleprompter, right? And what did he say? I swear to God, he said this. It will be unprecedented for the court to strike down this law. That's why I also go. If you go to the back of my book, I have a top 10 list of unprecedented quotes. It's in the appendix. I insisted on that. It will be unprecedented for the court to strike this down. The president said this would bring us back to the Lochner era. You have a sitting president talking to the Supreme Court through a press conference saying, don't do this, this is Lochner. Now, if you were my ConLaw class, you would probably say, well, that's a big deal, right? But most ConLaw classes think that Lochner was the most evil thing ever, and it was worse than Dred Scott, and allowing bakers to work too many hours is worse than putting blacks in segregated train cars. So in other words, Lochner is a pejorative that law professors use for something that's really evil, right? It's like Voldemort, right? You don't have to say what it is. He who shall not be named, Lochner, right? It brings this fear and the heat from the baking oven. So if you ever come to my office, I actually have this poster of Lochner's Bakery. I found it from an advertisement book in the 1900s from Utica, New York, of the freshest baker in town. Anyway, other people, Senator Pat Leahy, the senator, said the Chief Justice needs to be a Chief Justice for all of us, speaking directly to the Chief. I haven't quite taken this position, but others have, that there was leaks from the court early on that the Chief Justice was on the fence. And people on the right and on the left waged a proxy war to fight for the Chief Justice's vote. People on the left said, don't do this, John Roberts, it'll be really bad. You'll put the court in election year. Don't be like the New Deal. Don't make Obama run against the court. Remember the court packing scheme. People on the right said, Chief Justice Roberts, grow a backbone. Don't be a wimp. Do the right thing. Well, in the end, he did something very interesting. So the opinion you read in class, I've read it now more times than I can count, and every time I read it, I'm still surprised at the ending. I'm still thinking, did this actually happen? And I'll give you an anecdote. So I had to give a talk in London the day that this case was being decided. And I knew in advance when this case would be decided, so I said, okay, here's what I'll do. The Supreme Court has decisions at 10 a.m. I bought a ticket leaving from O'Hare to London at like 10:30 a.m. I'm thinking, okay, nothing's ever on time at O'Hare. If you've ever flown anywhere to O'Hare, I've never had a flight on time there ever, for any people nodding. Nothing, an international flight too, it's never on time, right? So I'm thinking, okay, the Supreme Court starts at 10, you know, my girlfriend can email me the files at like 10:20, I'll download it on my laptop and I'll read it on the plane. You know, I have like 8 hours, what am I gonna do? I'll read the entire file, right? So, you know, 10 o'clock happens, 10:05. Okay, they decide one case, it's a free speech case. I download it, no big deal. Okay, 10:10. There's another case they dismiss, not really important. Okay, then it's 10:15. And at this point, they're closing the cabin doors going, oh my God, are we actually taking off on time? I said, this can't actually be happening. I was banking on a delay. I was like, oh my God, we're actually taking off on time. Like, you know, anyway. So by 10:20, I have all these G chats or timestamps, right? The Supreme Court's website is totally down. It was flooded. The website was totally down. Moments before we take off, I was like texting my girlfriend, like, what the hell's going on? She's like, I don't know. They're still trying to figure out what the opinion says. I'm like, what do you mean they're trying to figure out what the opinion says? I was in such dark. As we were taking off, the wheels were lifting up. I got one last message. She wrote to me, the Chief Justice voted to uphold the laws of tax. That was the last message I had for 8 hours. I was in radio silence for 8 hours, crossing the Atlantic, with a message that the Chief Justice wrote to uphold it as a tax. I had this weird existential crisis because I was at 35,000 feet and I'd followed this case so closely for like, 3 years and think, what the hell is going on? And below me, there was madness ensuing in Washington and madness across the country. And you can find it was a blog post where I was saying, I don't know what the hell's going on. I really like weird journal entry in my blog. It was a very confusing time for me. But eventually I landed. I was massively jet lagged. I got to the airport to clear customs, and I was like looking at me at 100 emails, like what the hell happened? And then finally, I think I stayed up all night. I had a presentation next morning. I wasn't even awake. I don't know how I did it. But this was the chaos of Mr. Chief Justice. So what happened? The opinion had several components. Okay. The first component, which was joined by 5 votes, more or less, found that this was not a regulation of commerce. That rather than regulating commerce that existed, it forced people into interstate commerce. The Chief Justice wrote, citing McCullough, that the enumeration of presupposes something. The Chief Justice wrote, the fact that Congress can regulate commerce presupposes commerce exists. If Congress can shove you into the stream of commerce and make you do stuff, they can regulate anything. Commerce Clause violation. Second, necessary and proper clause. This is where they go in a place I didn't think they would go. So we've learned since McCullough v. Maryland that necessary and proper clause is very broad. Excuse me. And we studied that under the Hamiltonian reading, necessary means convenient, not strictly necessary. So if the government wants to implement a nationwide war on drugs, a convenient means to that is to ban locally grown marijuana. And in Raich, the court said that was necessary. But what about proper? So where the chief took this is really interesting. He said, even if something's necessary, it's not proper. And what makes it not proper? Because the tail wags the dog, right? The government, of course, has an interest in regulating the health insurance market. That's fair. But the power to make people buy it is such a great and independent substantive power that it can't be attached as incidental to the Commerce Clause. In other words, the necessary and proper clause can't be such a big aspect. You can't make people buy stuff. So even though maybe you could criminalize locally grown marijuana, you cannot make people do this. That's not proper. This was basically the first time in American history that a law was struck down as not being proper. Hinted at it in Printz and otherwise, but it's never actually been the holding of the case. There were 5 votes for that as well. Then we get to the fun part. This is what drove everyone crazy in Washington, D.C. Why would the Chief Justice spend 40 pages discussing the Commerce Clause and Necessary and Proper Clause if he was uphold as a tax? Wouldn't the reasonable thing to have done was say, well, because we can uphold this as a tax, we don't need to reach the Commerce Clause issue. We don't need to reach it. But the Chief Justice gave us 40 pages of dicta, or I don't know what it is, about the Commerce Clause. No doubt to help some future constitutional challenge, right? But the court's holding here was very significant, okay? The Chief Justice accepted the argument of the government. So here he follows. On the one hand, for purposes of the Anti-Injunction Act, Obamacare is not a tax. We can hear the case now. On the other hand, for purposes of the Constitution, Obamacare can be read as a tax. Wait a minute, Josh, how the hell does that work? The Chief Justice said, listen, Congress did not design this as a tax. They didn't. They called it a penalty. The president said it wasn't a tax, up and down. But as a court, we have an obligation to read a statute in a way to uphold it. If we can read a statute in 2 different ways, one invalidating it and one to uphold it, we should choose the pathway of upholding it. Okay? So even though, for purpose of the statute, we're going to call Congress's bluff and say it's not a tax, for purpose of the Constitution, we will save it. This is what the Chief Justice called saving construction. He found a way to save the statute. So now, John Roberts is responsible for the largest tax increase in American history, right? He imposed a tax on millions of Americans, which we now are paying as we see. It was a joint dissent. What do we mean a joint dissent? No one signed individually. Scalia, Kennedy, Thomas, and Alito signed it jointly. That's very rare. It hasn't happened in probably almost 25 years. Okay? They didn't join the Chief's majority opinion. They wrote a totally separate opinion, making almost identical points. Well, so why would they just not join its opinion? Well, there are rumors, which I don't think are true, that the Chief Justice changed his mind. And I wrote about this in the book. But rumors leaked that the Chief Justice initially was looking to invalidate the law, was kind of on the fence, and then decided, you know what, I need to uphold it. So some people argue that this was a way for the dissenters to spite the Chief. I don't buy that for a second. Justice Thomas would have voted to reverse the 20th century. He'll basically argue that all these precedents are wrong, Wickard and Raich are all wrong. Let's go back to the original meaning of the Constitution. Let's go back to Jason's point about Kagan and Breyer. They joined the Chief Justice on the spending clause. And here's what they said. It's a coercion. Congress cannot give you the choice of accepting these new conditions or losing all of your money. It's like I put a gun to your head and say, your money or your life. Is there really a choice there? No, said the Chief Justice, joined by 5 others, or 6 others. So there actually were 7 votes for this. But what they did, the Chief and these 3, was very creative. They said, give states the choice. If states want to expand Medicaid, they can. Take the new money with the conditions. If a state like Texas says, hell no, we won't go, they don't have to. And they can keep their old money. So now we're in this bizarre situation where 20-something states have it and 30-something states don't. But I'll tell you, one at a time, they'll trickle off. And we'll get to the point where all the states will be a part of this new agreement. And once you join, you cannot leave. It's like the Haunted Mansion at Disney World. Once you enter, you can't leave, right? You're stuck. Okay? Justice Ginsburg and Sotomayor have upheld the entire law. And they argue that this is ridiculous, right? that health insurance is merely a way of financing payment for something you'll need. Everyone will need it. And this law merely controls when you pay for it. Justice Ginsburg's opinion also made many references to the New Deal with Social Security. And she was trying to make a very clear point that we should not repeat the mistakes of the New Deal court and challenge the president and Congress. That they want to enact these progressive laws, the court should not stand in their way. But in the end, the law was upheld nearly in its entirety. Okay? Okay, that's all I got for today. I was talking a lot. Do you have any questions? I didn't mean to lecture too much, but it's the only way I can get through the entire topic in one period.
You said you don't think Roberts switched, but what about the fact that the joint opinion is written in such a way that it sounds like it was an original draft of the majority?
It's not true. No, I mean, so Jason raises it's a fairly good theory, which a lot of people think. The theory was, for the last minute, they were trying to persuade the chief to join their opinion. I have, from my own intelligence, this happened fairly early on. That by some point in April or May, the Chief Justice decided he was going to write by himself, and he wasn't going to change his mind, and they proceed on that path.
I don't think it was a last-minute change, but I think it was done deliberately.
No. So, I mean, that's what was reported. Yeah, no, but I have, based on my information, the chief made up his mind fairly early on and was not going to switch from it. Other questions? Yes?
I have a question. It's not necessarily, but I'm just curious, how often do leaks actually happen?
Almost never. Almost never. I mean, in the last 40 years, maybe a handful. And they don't happen because the clerks are sworn to secrecy. And they know that if they leak something, their careers will be over. That people will just blacklist them. So, to talk about the leak, this is something that has been authorized by a justice. And I don't say that lightly. Right? A justice would have had to authorize this information to come out. Because no clerk would be willing to risk his job for something like that. We'll maybe know in 20 or 30 years when we read the papers what happened. I will be the first one at the Library of Congress waiting for it. I'll be the only one young enough to actually be alive when it happens. Because usually the justice probably, I mean, I don't think these papers were released for another 30, 40 years. So yeah, I'll be there, whatever, right? But this drama playing out with the president and the senators making all these comments. I know for a fact that people got these leaks. I know they got this information. And they were trying to persuade the Chief Justice to change his mind. So there was an entire campaign to move the chief on this. And in my humble estimation, it backfired because it made it look more political. And it made the chief more likely not to want to do this. I'm very nervous about all this stuff of politicking. I mean, we're having this right now. Right? On Wednesday, the Supreme Court will hear arguments in a case called King v. Burwell. And I'll briefly summarize. The Affordable Care Act says, states, you go establish these exchanges, you know, like covered California. And this allows people to go online and buy health insurance. And if you do this, right, if you establish an exchange, we'll give you all of this money, subsidies, which will decrease the cost. But if you don't establish an exchange, the feds will come in and do it. This is why we have this website, healthcare.gov, which I'm sure some of you are familiar with. The problem is, if you read the statute, just the text, there are no statutes made available for the federal exchange. Now, the federal government's been paying out these subsidies now for almost 2 years. Challengers say this is illegal. They can't spend this money. If this provision is struck down, millions of people will be unable to afford the health insurance. The premiums that you pay in healthcare.gov are not the real prices. Those are the sticker prices, right? The real price is probably double. So unless Congress can get its act together and do something, people will be unable to afford health insurance. And there's been a sustained effort by supporters of the ACA to say, if the Supreme Court invalidates this law, people will die. There have been briefs submitted to the Supreme Court called, I call them the people will die brief, which says, without this, here's when people will lose health insurance and will die. Politicians saying, don't do the Supreme Court, people will die. This effort to try to make these arguments based on policies which are totally ancillary to the issue of statutory interpretation trouble me greatly. The Affordable Care Act will be in litigation for the rest of our lives, right? People can be challenged this forever. And anytime any provisions in question, the response is going to be, if you take X away, people will die. That makes it impossible to have a legal debate over a serious legal issue. And this scares the wits out of me. And I'm not trying to minimize the pain of human suffering, right? I signed a brief in this case. I submitted a brief saying that the government should lose. But the entire nature of how this debate's been transformed, I think, stems from the efforts to delegitimize the Supreme Court in the NFIB case. Other questions? Eddie?
Seems like you have the politicizing of the court from one perspective, but then on the other side of the coin, you have this, the court seems to be becoming increasingly celebrities. They're in the popular culture. They seem to be marketing themselves along those lines.
Oh, it makes me sick.
That seems to be just a dangerous combination.
It's a serious danger. So, I mean, I've discussed this, but Justice Ginsburg is often called the notorious RBG, and she's become this kind of pseudo-celebrity. And the problem with this is it defeats independence and impartiality. She actually has a following, and she doesn't want to disappoint her fans. Justice Sotomayor has been called the People's Justice, which makes me crazy because she's not the People's Justice, she's the Constitution's Justice. And there was actually a report by Joan Biskupic that in an affirmative action case, Fisher case with UT Austin, Justice Sotomayor did not dissent. And Joan Biskupic reported that Sotomayor was that people criticized her for not dissenting, and she was upset by that. So she issued a very strong dissent in the Schuette case, which we discussed. So in other words, Sotomayor's Schuette dissent was occasioned because people criticized her for not dissenting in the Fisher case. This is dangerous territory, folks. Dangerous when you make these people demagogues, right? Or demigods, whatever you want. It becomes difficult to detach the person from the case law. And to criticize the justice, now you're criticizing, you know, women's rights or reproductive justice, whatever other, you know, meme of the day. These are heady times, my friends, and I am not comfortable with this at all. So if you'll see my less than enthusiasm for the same-sex marriage case, this is probably why. Whatever, it'll be done in a few months. What else? Any other questions? Have a great week. I'll report back next week with the with the King v. Burwell case.